The past few years have witnessed an increase in the number of people and organizations who have registered their displeasure with Zimbabwe's judiciary. Among some of the most controversial cases is the Kachipare case, which may see a woman, Sokolusne Kachipare, hanged for what some consider to be a gross miscarriage of justice. Others include the Evelyn Hunt case, where the partially blind elderly lady faces eviction from her flat of 27 years, and the Indu Plume Rule case, where people are being forced to pay back to banks more in interest rates than the initial sum borrowed. These and other cases have led civic organizations and other pressure groups to ask the question, to whom is the judiciary accountable, and in cases where justice is not seen to be done, who shall judge the judge? Africa Dialogue, a Zimbabwe-based conflict resolution organization comprising various religious groups, has also echoed the same sentiment. Its leader, Reverend Johannes Danga, says Zimbabwe can never have sustainable peace and the rule of law without justice.
The leader of fraternity has the audacity to march to call for the return to rule of law, and yet not a single, not one of them has called for justice.
With calls for a speedy resumption of the constitutional review process gathering steam, many believe that the question of judicial reform must take center stage and allow citizens to be the eagle that is always hovering above both the executive, legislature, and judiciary. But with the judiciary guarding and guided by century-old traditions, reforms will certainly not come easy. In Harare, Obel Mpofu, the BBC News.
It is against this background, given in the previous story, that the National Development Assembly decided to host a public meeting to debate the judiciary and the way it has conducted itself in the process of dispensing justice in Zimbabwe. However, traditionally, judges do not participate in public debates and were therefore not represented at this meeting. The organizers felt, however, that people can still debate the matter without judges being represented, for at least to make their views known. Mtungwa Mawere opens the debate by giving an outline of the judiciary.
It is clear that democracy will remain a distant goal until the issue of judicial reform is addressed by this generation of political and economic leaders. It is important to underscore at the outset that judicial reform, for better or worse, is an inherently political rather than technical process. We in NDA believe that judicial reform has been overlooked in the overall reform agenda, and it is important that this matter receive a very high priority if we are to avoid an alarming trend toward democratic decay. We hope that this conversation will go a long way to fulfilling an important gap in our understanding about democratic consolidation in Zimbabwe. Not only is it one of the few that concentrates on the judiciary, it practically stands alone in providing a framework for a dialogue among stakeholders. Above all, judicial reform is a political process whose success or failure depends not just on technical or administrative tinkering, but on the determination of key political actors to establish the rule of law. Scholars of democratic consideration in Zimbabwe have long insisted that sustainable democracy depends largely on institution building and state reform. But in spite of the considerable attention given to executive and legislative institutions in recent years, we still know woefully little about the judicial branch in Zimbabwe and its relationship to politics and transformation. Without an accessible, impartial, and efficient system for the administration of justice and resolution of disputes, there can be neither fully consolidated democracy nor a smoothly working market economy. Involving citizen confidence in the judicial system and the accountability of political authorities are not only necessary imperatives for an efficient and effective democracy, but important platforms for economic transformation. A sound judiciary is critical for building popular support for democracy and laying the foundation for sustainable economic development. But it is our contention that we've made virtually no progress toward building a more effective judiciary. The format of our dialogue is informal. We will allow for an exchange of views rather than a monologue from this table. The speaker, I think, will introduce and maybe provide the framework for our discussion is the Attorney General. It's unfair to ask him to give a framework because he is not a judge. He is just a chief law enforcement officer and advisor to government. Sometimes it's difficult to bring the bench to the bench here. So we have to discuss the bench without the people who sit on that bench. So our dialogue will be discussing absent people. But the absence is important because no judge who sits on the judiciary today was appointed by Ian Smith. All the judges that we have today is not an inheritance. It is our own choices. And it is those choices, even if we seek to reform, that we have to confront. The choice we have for some who don't know the landscape of the judiciary, we have 23, I think, gentlemen and some ladies who sit on the bench, 5 of them on the Supreme Court. The balance, they sit on the High Court. We have 5 Supreme Court judges. 2 of them, Justice Judiciary and Justice Sandura, are black. 3 of them, 2 white and 1 Indian. That is, we have 60% that we can classify. It depends on as non-indigenous in the sense of the land dispute. High Court, there is 18, 7 of them are non-black. So in a country where we have almost 18 million people, the issue is that we have 43% of the bench that is non-black. It's not a sin. It's not, this judiciary was not appointed by Smith, as I understood. So don't take anything out of it out of context. When we look at the stock exchange of Zimbabwe and just look at the companies listed, who are the legal advisors, who are not the legal advisors, you find the traditional names: Wintertons, Triple G, Scanlon and Wilderness, Camden Imerman, Atherstone and Cook, Coughlin, Walsh and Guest, Gallop and Blanc, Hann and Black and Bank, Calderwood. All these firms, they are represented on the companies, on the stock exchanges advisors. 2 companies listed. Why do we have few blacks on the judge, on the bench? It is not because of race that we have few. It is because not many blacks want to serve on the bench. If you don't invest in an outcome you seek, then you won't get the outcome that you desire. So all the judges that were appointed, the people who offer themselves to serve on the bench, invariably tend to be those people who are well-to-do. Because sometimes to go on the bench, it also means a sacrifice, because your claim on income compared to your counterparts in private practice is qualified. You are subject to public scrutiny. You are also subject to accountability. When they say belt tightening, it also affects judges. So traditionally, you find that judges in countries that have mature democracies that also reflect the demographics of those countries, you find that people who serve in the private practice, they make a lot of money. Once they make money, they now move to the bench, maybe to protect interest. But some of the people who serve on the bench, who are black, some of them have no interest to protect because they have not made the resources. And we are all to blame, so we are all responsible because we have chosen not to use our own lawyers. We train them, they go to university, and yet when they finish university, their claim on income is qualified. It is not a responsibility of government. 1980, there were only 40 black lawyers. Now there are more than 400 black lawyers. And yet collectively, those 400, their claim on income is qualified. So when we look at political, social, and economic transformation, as we look at the transformation of the Constitution, the debate is also polluted by lawyers. And yet in a country where we have 13 million people, or close to 13 million, there are only less than 1,000 lawyers. I think there are about 800, close to 800 lawyers, with the capacity to confuse and to bamboozle us. So at the end of the day, we may not know where our rights are. As I challenge some at NCA, that should we worry about economic rights or political rights? Which comes first? Whereas we have political rights, we have ended up blaming the people who sit on the bench for the mistakes that we make with full political rights. So you can't blame your own instrument for transformation. So I think the role of the judiciary is critical. The investment that we make in our lawyers is also an investment that is worthwhile. And our capacity to process crimes, our capacity to dispense justice is invariably related to our capacity to invest in that system. And the question, I think, really for the Attorney General is to look at the Attorney General. For some, they don't know who he is. That's the first thing. He's a new appointment, but old in the system. For some, we don't know what the role of the Attorney General is or should be. Some have seen cases being dropped. Some have seen criminal cases. Some have seen civil disputes being arbitrated in the court system, spending 5 years or 10 years. And some have blamed the Attorney General's office for an inefficient administration of justice. Does the Attorney General have the adequate claim on resources, or is just a reflection of the qualified claim? Does he get the residue of our lawyers, or does he get the best of our legal minds? Are we prepared to pay for the best minds in the public sector, or we are prepared to condemn them in the public sector? So for those who serve and those who have been served with notices, each notice for land designation attracts litigation. attracts processing. And while you are processing land dispute, you also have to process criminal and civil disputes. Does the Attorney General, is it politically correct? Is it millennium compliant? Or is there a millennium bug? I think all those questions, they can only be answered by none other than the Attorney General, Mr. Jukowela. Thank you.
The Attorney General is the principal government legal advisor, or the government's chief legal advisor. He is the person who is responsible for giving all legal advice to government, that is either directly through ministers, through ministries, government departments, advice of whatever nature, criminal, civil, legislative drafting, etc. His office is a public office, but does not form part of the public service. In other words, he is not a civil servant. His office is a constitutional office, which is established by Section 76 of the Constitution. And by 76, and his appointment is by the President after consultation with the Judicial Service Commission, more or less in the same way as our judges of the High Court and Supreme Court are appointed. He has the same qualifications as those required of a judge of the High Court or a judge of the Supreme Court. Now, in order to perform his functions as the government's principal legal advisor, the Attorney General is assisted by various officers. In fact, there is a structure for his office, which consists of the Attorney General, the Deputy Attorney General. Then there are 4 divisional directors, and each division specializes in an aspect of governmental work. We have the main, or what has been generally called the main division, primarily because of its size. Secondly, because it basically deals with people's liberties, people's lives. That is the criminal division. That is a division that's generally in contact with members of the public. Then there are other 3 divisions. One which specializes in government legislative drafting. This is the division that drafts all legislation that is eventually brought before Parliament, which is part of the Attorney General's function of translating government policy into law. What basically government has, or government ministries, is once the policy of the ministry is formulated and accepted by government or by the cabinet, and if it is intended to reduce that policy into law, then instructions are given on that basis to the Attorney General, who in turn prepares or drafts the necessary law. Then the Attorney General also looks after the government's commercial interest and civil disputes. He has what is called the civil division, which deals with all government civil litigation, all government commercial contracts, negotiation, renegotiation of all government's commercial contracts, and defending the government in all civil litigation. And then finally, we have the division of legal advice, where this title, principal legal advice, is generally derived from. This is the division that provides government with all general legal advice, including statutory interpretation. It, in fact, services all other divisions of the Attorney General by assisting them with advice on statutory interpretation, advice on constitutional issues, deals also with the government's international relations, including participation in the negotiation and drafting of international conventions. That being the one thing that, of course, must be said at this juncture is that in the yesteryears, the role of the Attorney General was straightforward. First, all one knew was basically your main function was criminal prosecution. That is in this country. And secondly, civil litigation, civil defenses, and advising the government on its commercial interests and drafting law. But today, the role of the Attorney General has become more complex. More particularly, especially when we are speaking about Zimbabwe today, more particularly in the light of the crucial initiatives that have been undertaken by government in the field of economic policy, namely the land redistribution program and what is now generally called the Millennium Economic Recovery Program. What then it requires? It simply does not require a dogmatic Attorney General who simply interprets the laws that are in existence and drafting laws as and when instructions are given. The Attorney General now needs to take a more proactive role in constitutional reform in order to accommodate these new policies and these new realities. It must at the same time be admitted that the interface between economic policy and constitutional law is not immediately apparent, even to the specialists in the fields. And when I say that, I'm not only restricting this to lawyers, whether they be government or lawyers in private practice. That includes judges too. Now, constitutions all over the world in the past have been primarily concerned with the diffusion of political power as between the executive, judiciary, and legislature. Rarely have these constitutions addressed themselves specifically to the diffusion of economic power, whether as between the state and private citizens and corporate bodies, or as between various social groups within a state. It must be realized that today, that economic and political power are ultimately inseparable from each other, and that our constitutional lawyers would do well to give more attention to the interaction between the two. In Zimbabwe, what we have attempted to do is, in attempting to address the historical injustices which basically are pronounced through our law, has been to amend various provisions of our Constitution in order to remove the objectionable features, in order to bring about this interface between economic and political power. And this has been as a result of the realization that without economic empowerment of the majority of the people in any community, no number of rights listed in any constitution can guarantee the dignity and freedom to which every individual is entitled. Our historical experience has taught us the important role that constitutions play in the legitimization of economic exploitation. I'm not being political. I'm just simply stating realities. And also in governing the power relations within a community. You see, insofar as constitutions faithfully express what a German jurist, Kelsen, called the grand norm, that is to say, the fundamental norm which orders the relations of power within a state, constitutional provisions are of the greatest importance in putting forward the aims that a nation sets for itself. In order for us not only to give a meaning to this new reality that the nation, especially Zimbabwe, has now to direct its attention to in order to address the contradictions within our society, make anything, whatever, no matter how colorful an expression you may use, whether you call it economic empowerment, democracy, and so forth, in order for us to realize that, one needs, first, because there is no way, as I have said, it is the Constitution that expresses the policy of a nation. It is the policy, the Constitution itself that governs relations within the society, as interpreted by the courts. You will then need a very responsive judiciary. Not only do you need a proactive Attorney General, you need a very responsive judiciary. You also need a very innovative legal profession, which basically is supposed to assist and guide in the protection and respect for human rights. The criticism that perhaps we lawyers should readily accept is that because of this traditional approach, which was again enshrined and guided by our constitutions, it has been basically what we have been doing till today, that law or rights is a matter of rules, that comply with the rules. It is basically the relationship between the judiciary and the executive, judiciary or executive and the legislature. If the executive has omitted to do this, then you can't have this. Damn the consequences. Comply with the rules. I think with these a few remarks, I just intended to provoke discussion. Maybe perhaps before I sit down, maybe one thing that I might touch, which Mr. Mawere touched on, is recently there has been, in fact, it starts with the press and eventually what is the information that is then communicated to the public. There has been, it appears, a total misunderstanding in regard to the handling of the so-called high-profile cases by my office. First, there have been reports by the press themselves. The magistrate has withdrawn a case. First, I must correct that impression. The prosecutor's what call is dominus litis. The magistrate or the judge has no authority to withdraw a case. A case can only be withdrawn by a prosecutor, not a court. What a court can do is to dismiss the case or dismiss an application, but never to withdraw a case. Secondly, there has been also confusion in regard to what happens where a case has been withdrawn before plea. When we say before plea, is before a person has taken the stand and has been asked as whether or not he denies, whether or not he admits the offense. A withdrawal before plea does not affect the future prosecution of the matter. A withdrawal before plea is done for a number of reasons. Either the court feels that the person has been on remand for unduly long, and that is not fair and just to continue putting a person on remand, and that if the state intends to proceed with the matter, it can pursue its investigations and bring the matter to court for trial when the state is ready. The other circumstances where the state or the prosecutor may withdraw before plea is where the prosecutor feels that as at that moment there is insufficient evidence or insufficient facts to justify the continued remand unless if further investigations result or produce further evidence that will justify proceeding with the matter. I thought maybe I should just make those remarks before I take my seat. Thank you.
Although there were no judges present, some organizations at this meeting gave their views on the judiciary, such as the Zimbabwe Farmers Union, which was represented by its president, Silas Hungwe. He discussed the judiciary in the context of the land reform process going on in the country.
Unfortunately, there are a number of cases in which there are contradictions in the provisions for individual rights versus community rights. On the question of land, the contradictory issues are: 1, individual property rights versus moral aspects of community welfare, equitable distribution of land, and the need for national stability. Whose rights come first, and under what circumstances are more groups more equal than others? Are the needs of the smallholder farmers for land less important to the needs of the large-scale commercial farmers? 2, following the principle of equal rights for all, can the judicial proactively ensure an environment with equal rights without political enforcement? How come Zimbabwe had to be liberated by war when the courts were there? To what extent is the judicial independent of government, and do they have the capacity and mandate to try government? To whom is the judicial accountable? The poor majority, the rich, and the influential, or government? 4, the divergent interests and views of the different stakeholders on land make it difficult to agree on priorities and the best way forward. For issues requiring community agreement for success, the judiciary may be the poorest framework for achieving consensus. The best results are achieved through genuine dialogue among the stakeholders. 5, the implementation of the judicial decisions requires a government that respects the rule of law. Taking government to court, as in the current legitimation between the Commercial Farmers Union and the government on the legitimacy of the amended framework, Section 16 of the Land Acquisition Act, Chapter 20, is not likely to bring any fruitful results if the government decides to ignore any decisions made by the judiciary. The multi-stakeholder dialogue must focus on achieving agreement on the shared values first, so that the basis for comparison of the divergent interests can be set. It is also difficult to achieve a win situation where there are many different interest groups and without mutual trust among them. Some commercial farmers' unions have been continually shifting goalposts ever since the land debate started. Under the multi-stakeholder dialogue, who has demanded to represent, and who at what stage are they to be involved in the decision-making? Many times the disadvantaged groups never get the chance to express their views on issues that affect them. The challenge is to be able to identify the beneficiaries or affected communities and allowing them to come up with solutions to their problems without manipulating the results to cover the interest of the influential groups.
Other invited speakers came from the unions. A unionist, Mr. Bungu, felt that the interests of the workers are not respected when it comes to litigation in the courts between workers and employers. He felt that judgments in the courts are in general against workers who have no resources to fight their cases.
In all cases, when we demand what is rightfully ours, we find ourselves first with litigation. And in all these cases of litigation, we do not have the resources to defend ourselves. Why? Because the system has made us poor. Employees have been retrenched in Zimbabwe today, in our Zimbabwe. These employees have worked for certain companies for say 32 years. These employees, when they are retrenched, they are forced to go. Not of their own will, but they are forced to go without having committed a crime. And at the end of the day, this employee is given 10,000 as a thank you. And they say that's a golden handshake. Yes. The employee, does he have accommodation? He doesn't have accommodation. Maybe all these questions, Mr. Chairman, they are coming about because of the topic here, the judiciary. What role do they play? In some of these cases, we have tried even to go to court, and at the end of the day, we find ourselves poorer and poorer and poorer because all the judgments are given in favor of the multinational companies. Right? It depends. Economic power, how much money do you have? It doesn't have anything to do with who is right or who is wrong here. So this is the situation which we find ourselves in. And I have a very sad case of someone who has been to the tribunal, the Labor Relations Tribunal. His case has been there for the past 3-4 years, right? He's not supposed to look for a job, because if he looks for a job, the case will fall away. So it's unfortunate that we find ourselves in such a situation. We thought the Labor Relations Act was there to protect us as legislation, but it's unfortunate that it's not protecting us. The Attorney General's office, maybe, there's also a need for his office, the Attorney General, to also look at the Labor Relations Act vis-a-vis other acts which are in operation in certain organizations. For instance, I'll talk about the Urban Councils Act vis-a-vis the Labor Relations Act. There are so many conflicts which are associated with this, with these two. And as a result, the Attorney General, fortunately I've seen him only today. If I can come to his office, I'll also bring a paper which we have prepared about the conflicts which are there. And there's a question which was asked, whose interest does the judiciary serve? Is it serving the interests of the nation, or is it serves the interests of a certain particular class or a group of individuals or multinationals? There was a question which was asked when I attended a certain seminar. There was a question which was asked to Tisho Neshona, mo translator futhi kana judge akupenga munoziva sei kuti akupenga. Okay, there's a case. Because anti Zutaronzi, sorry, I'm not being political. Zutaronzi wamgabe wakura, anti those Zutaron. Wamgabe wakura ngawachibva kwendo wechidika andika. Right. Kweyo majaji asati akure. I was looking at the Magwan case. You see, in Magwan's case, akauraya, but Magwan today, where is he? Right? We have a case, equate that case to the case of this boxer of ours from Bare, Mosquito. Right? If you look at the two cases and the judgments which were given, then really, Attorney General, we are lucky to have you tonight. There is something wrong with our judiciary, and it has got to be corrected now. In rounding off, sorry if I bored you, but in rounding off, our request is that why can't we have a judiciary which has got a human face? Right? A judiciary which is accountable to the constituency, which is us, the people who pay taxes to the government. Isu ashandi toda kuti my judgments are in our favor. When we go on strike, you will be told that a strike is illegal. There is no legal strike. We are all aware of it, aren't we? Kana maenda pa strike, employer animal, the employer has got the money and you have worked for that money. You know that the company made a profit of 60 million. And what you really want, the increase which you really want, constitutes of only 1.5 million. And the employer says, no, I can't give you. You go on strike. The next thing is that you are given a show cause order. Why did you go on strike? But why don't you come first and say to the employer, let's see your books, because these employees are your employees, they've worked here. So in other words, it's like as workers, I'll say this, as workers, the feeling generally among us, the workforce is that the judiciary is not representing even the views of the workers who are maybe paying their salaries at the end of the day. And maybe, Mr. Chairman, would request that things change now. Thank you.
Okay, thanks. War veterans leader Chenjerai Hunji was also at this meeting and felt that the present laws are hindering the government in moving fast in acquiring land and resettling people. He cited clauses which allow farmers to appeal against land acquisition.
There is a problem of how to resettle the people. Of course, there's pronouncement that there is fast track. But the fast track which has been done has been done by the war veterans and is not supported legally. Here we meet that the government is supposed to be settling people now, but there are laws which are handicapping the government to make the real fast track program go ahead. This is a problem which I don't understand. Maybe because I was not in the last parliament. Now, Section 57 was amended to say that the government has got the right to acquire and redistribute land, but there was a clause left out. The appeal which the white man today is clinging on to, is there somewhere something should be done to get that thing off so that our fast track is really a fast track? Because we have taken the land liberation as fast track, it must be supported and be complemented legally. But I don't know why the legal advisors didn't take into advising the government about this appeal aspect of land, which gives the white men some excuse of refusing with our land. We are persuading them now to give us our land. When they came here, they didn't persuade us for them to take our land. They really massacred us for them to take our land. There was no law. I'm called one of those people who is lawless. Well, that's fine. I accept that, as long as it is something that goes with patriotism and for the love of my country. And I would want the advice on that question. It is very important. Can you advise us on how we left the appeal aspect in as far as land is concerned, and we want to give the people the land now and today? We have that stumbling block. Thank you.
Chairman of the Anti-Corruption Task Force in the National Economic Consultative Forum, Philip Chiangwa, made a presentation on corruption in Zimbabwe and said that to curb corruption depends on the extent to which the law is applied.
Ladies and gentlemen, we cannot attempt to set up an anti-corruption commission and task it to rid society of this scourge when on the ground the dynamics are not right. If our people are failing to transparently access their God-given birthright, land, how can we blame them if they resort to underhand deals to acquire SEM? Blame them, yes, we can, but will that be enough to clean society of the vice? The answer, ladies and gentlemen, is an unqualified no in big capital letters. People act to satisfy their needs, desires, and aspirations. As long as there is need for the cultural right to land in cities, towns, growth points, and rural areas, people act corruptly to access that right. If our people have no land and are impoverished as a result, and then they act corruptly to take advantage of the disadvantaged, we should not blame them. Even the proposed anti-corruption commission will not have a positive impact in curbing the rampant corruption until such time as basic cultural dynamics are put right. Therefore, the thesis on my discussion here will not be complete if the aspect of the law is not dealt with. A successful program of action to rid society of the pervading problem of corruption is in the extent to which the legal system will be used to discourage corruption. Yes, the Anti-Corruption Commission will in many ways complement existing legal structures in curbing corruption, but to what extent? However, the agency or a commission will make a difference, will be the function of the law interacting with political and cultural values. It must be understandable that our laws, like many laws elsewhere, are rigidly in favor of the status quo. At present, other than the Prevention of the Corruption Act, there are no other legislative and institutionalized deliberate instrument to survey and monitor compliance. Therefore, we are in effect witnessing its rampant corruption in the society without the law enforcement institutions giving justification for the need at this stage to establish an anti-corruption surveillance and compliance agency. One would like to know the definition of corruption. Ladies and gentlemen, some of you may ask what this monitor is called corruption is. You are not alone if you have a dilemma in defining corruption. The Collins Dictionary defines corruption as being open to or involved in bribery, being morally depraved and unreliable through errors or alterations. Corruption is an act where a person in control and responsible for delivering obligations of his responsibility demands certain performances from another, reasonably seeking the service before performing the obligation. Corruption manifests itself in various forms. It could be a straightforward act of bribery where consideration out of contract is paid to induce favorable outcomes in a performance. The nature of the extra consideration can be anything with a monetary value. In other cases, it could be a deliberate act to present barriers and create unwarranted delays in delivering of a performance, which needs greasing to get the performance concluded. In yet another case, it can be a case of simply using undue influence of power bases to achieve personal ends. Then the contradictions of indigenization and empowerment against corruption. We must all be too familiar with the government philosophy on indigenization. To what extent has it succeeded and for which benefit? It is not clear to all of us that real beneficiaries of the government's commercialization and privatization as well as land reform programs are those who are well off economically, well connected to the powerful, or capable of greasing the pockets of people. So many people do, of course, want to know that who is the biggest corrupter vis-a-vis politicians and the private sector.
Students and other members of the general public who were present also gave their views through comments and questions which were directed to the Attorney General.
Very bad for those 10 people. 5,000 each. For 10, $50,000. Yeah, or Ashwa. Community service. Are you aware of that?
On the corruption side, the Attorney General has informed us that cases that have been withdrawn by his office will be proceeded upon by way of summons. Are there any examples in his lifetime in the ministry that he can cite where cases of the well-to-do have been withdrawn by his office and then he proceeded by way of summons so that he will be comfortable? On the labor relations side, the tribunal is with one judge, and we have known people to have been awarded cases and, posthumous. In an independent democratic society, we would learn people like is it really not painful for all of you guys to sit down to increase the number of judges in the court so that the proceedings in that court can be expedited? What are you doing in Parliament? Sleeping?
What forms of corruption do appear within the judiciary? And what sort of forms does corruption take within the judiciary? And what sort of mechanisms are in place to remedy it? And what sort of obstacles, things like contempt of court proceedings, are there as hurdles in redressing instances of corruption within the judiciary? And another issue was also how best can cases of corruption within the judiciary be investigated, given also the absence of knowledge on the general public of how decisions are arrived at? Because of late we've had in fact, quite some contradictory and shocking decisions, which of course have led some to believe that perhaps there could be some goings on, either on the bench or behind the bench or in chambers or wherever. If the learned Attorney General could just maybe address those specific questions.
First, insofar as withdrawn cases, well, I don't know what he meant by giving an example of a high-profile case, but this is something we do every day. There are several cases that are withdrawn for various reasons. First, it's not a practice that would want to withdraw a matter before we conclude the proceedings. Cases are withdrawn because something has arisen that creates difficult, first that makes it unjust to continue placing someone on remand and perpetually bringing him to court on remand when either investigation are taking unduly long to complete. Sometimes you may have a case whose investigation also involve interstate type investigation, and these by their very nature, because they will be affected by various other things, resources on the part of the police, they will need the necessary money to travel either to South Africa or to England. Sometimes the case itself may not involve interstate, but there may be other difficulties that give rise to the delay in the completion of investigation. I must first point out that the Labor Relations Court is not my responsibility. But of course, what we must understand is that in terms of the current statute, that's the Labor Relations Act, that court is constituted, in fact, only has a full establishment of two, the chairman and the deputy chairman. I know it's not really my area, but I am aware that there is debate on the question of increasing the establishment of that court in order that it effectively delivers what it has been set up to do. First, when you say judiciary, I am not exactly sure what you're talking about. Are you talking about the courts per se, or are you talking about the courts, the Attorney General's office? If it is the courts, again, as the chairman indicated at the beginning, at the commencement of this meeting, we do not have any representative of the judiciary. I am not a member of the judiciary. I'm basically, first as Attorney General, I'm the leader of the legal profession. As Attorney General, I'm the head of the government's legal services advisory sector, not the judiciary, which is a separate branch of government.